Okay, good evening and welcome to tonight's class. So, do we have anybody with questions about last week's assignments, discussion questions, quiz questions? No. Alicia, you said something about chapter 8?
Yes, sir. I had a question. I was wondering, I wanted to pick your brain a little bit on that discussion question.
Okay.
Where
All
the
right, and also, let me do this because Alyssa, you said something about you were trying to get in touch with me, and for some reason I'm not getting your emails, and the school has my new email address, but I thought I had typed it in for you, so I am going to type it in again. So it is gdeserio, the number 54 at gmail.com, and let me post that. And so just if you have questions, something's troubling you, or you've got an issue or whatever, just send something directly to that email, and it will come directly to me. So, okay. So we have 2 chapters tonight. The strict tort and the tort liability and strict liability, those sessions are being grouped together. I think those are sections. Tonight we're doing what, 10 and 13, so that would be 11 and 12. So we'll do those next week. And again, I think I've told you guys this before. You sent 2 messages through Canvas, so none of my messages are getting to me. So Eric Happy sent me a message, and so he said that he was going to update. For some reason, my old email address was still in the file, and he was going to update my email address to my gdeserio54 at gmail.com, so that then if you send it through Canvas, it should come directly to me, or you can just send it directly to me. So, okay. Okay, so I told you guys, so next week is spring break, and I am going to be gone the entirety of the weeks from Sunday through Sunday. So on Thursday this week, or maybe even Friday, depends on if Eric can open up the module that allows me to record lectures. I will have this lecture recorded, and then I will have everything for next week's class, and it'll be recorded. So at your regular time on Monday night, you'll come in. You'll log in just like you're logging in now, and it will be me, but just won't be a live version of me. So that will be the only difference. Okay. So let us begin. All right, so we're going to talk about some other different types of tort actions. Misrepresentation is it's kind of an area of fraud. All right, whenever we talk about it, and whenever it's pled, it's generally pled as fraud and misrepresentation because they're basically synonymous. If you're making a misrepresentation to someone and you expect them to rely on it, and they do rely on it, and if they rely on it to their detriment, then you in fact have defrauded that individual, just like anything else. So that can be a cause of action in and of itself. Conversion is the corollary to what we would call civil theft. It's like stealing something, but it's not deemed as a criminal act. It's deemed as a civil act for which you can sue someone. In the sense of conversion here that they're talking about is that if you make a false representation in order to obtain something from someone, then you've done it basically by deceit, and the deception is the misrepresentation. So that's what they're talking about with a misrepresentation under conversion. With regards to battery, if you do something and the idea behind it is to make them allow you or consent to a physical contact, then again, you made a form of misrepresentation. Now, in 35 years of practice, I've never pled this, nor have I ever seen it pled before, so that's kind of a stretch with regards to battery. Now, the last one, the intentional infliction of emotional distress. Intentional infliction of emotional distress is a cause of action which we call a bootstrap cause of action. In other words, you don't plead intentional infliction of emotional distress in and of itself. You plead it in conjunction with other causes of action to bolster other causes of action, but pleading it in and of itself. And in fact, I believe there's case law to this fact is that it's not enough, because you generally have to show some kind of physical harm to go along with the emotional distress. So the idea behind it is that if you maliciously spread lies about someone, then you've not really engaged in intentional infliction of emotional distress. If you spread these lies in writing, then you've libeled someone, and if you spread these lies, vocally, then you have slandered someone. So now there's also a negligent infliction of emotional distress, where an act of negligence it resulted in this emotional distress that someone is looking at. Here in Texas, we recognize this cause of action as a bootstrap cause of action, as a cause of action that can be applied somewhere else, but as a standalone cause of action, like a negligent, a tort, a PI case, we don't recognize that. So. The elements, all right, so if you make a misrepresentation, and you have to understand there's something that's called scienter. Scienter is the knowledge that you have at the time when you commit the act. If you have this idea that you're intending on making someone rely on your misrepresentation, you then have this what's called scienter. And the idea behind it is that you're misrepresenting something with the intent that they rely on it, and there's more to it than just relying on it. You got to rely on it to your detriment. So the idea behind it is that it's not enough that you intended someone to rely on it; they must have relied on it, and as a result of that it's what's called detrimental reliance. You've got to rely on it to your detriment. And at the time when you make this false statement, this misrepresentation, you either know that it's not true, or you have what's called reckless disregard for the truth. In other words, you don't care whether it's true or not. You're still making it with the idea that somebody rely on it, and then they rely on it to their detriment. So that's what we're talking about with regards to these misrepresentation type causes of action. And so it's the same thing but you've got to be able to show damages. Damages have got to be directly resulting from the misrepresentation that someone intentionally or with conscious disregard made, and upon which you relied, and therefore suffered damages. So it's more than just a misrepresentation. There's more to it than that. Okay. So this is just in a different format. Defendant makes a misrepresentation with intent to induce plaintiff's reliance. Defendant shows that he knows the misrepresentation is false, or reckless disregard, or reckless indifference. They rely on it, and they suffer damages as a result. So that is the cause of action. Okay, so I wish this was a little bit larger. I don't know how to enlarge this. Can you guys read that okay? On your screens? Yes? No? No, I can't either. And I'm trying to figure out where there was a different tool. I don't, this is different with collaborative Ultra. There was a different tool on my other, when we had the Blackboard that allowed, Susan, do you have a question?
There's a little button on the left-hand side right under the 3 lines. If you touch it, it'll pop out, And your
Did you
plus
mean
or
to raise your
minus.
hand?
Yes. You can hear me?
No. Okay.
Hello?
Okay, so it's in your book,
Okay.
so you got it, you can read it, you can see it. But it's just what's on the screen is very kind of washed out. Okay, so and all of the elements are there. So the whole idea behind it is, what you have to make a misrepresentation, a false statement of fact upon which somebody else relies. To who can it be made? It can be made to anyone. Okay, so Belinda, it's on the left up at the top. Well, that one says clear. This one says oh, wait a minute. No, that's just for my marker. That's shapes. That's pointer. Okay, well, anyway, so it's the same thing, square with a magnifying glass. Okay, I see it. Let's see if it will. Oh, well, it zooms in, but then it cuts it off. Well, I guess that's a little bit better. Okay, all right. So now I don't know what it's doing. I guess I got to take these things off of here. Okay. So the idea behind it is just understanding that that the defendant is aware or he's consciously disregarding it. In other words, he doesn't care whether it's true or false, and the individual relies upon it justifiably. In other words, it can't be an outlandish reliance. It's got to be a reliance that would be normal and the whole idea behind that too is that you've got to be able to show that the damages emanate from your justifiable reliance upon the misrepresentation. Okay. Okay, negligent misrepresentation. Same as, okay, so this was, remember I told you there was two causes of action. One was intentional infliction of emotional distress. This is an intentional misrepresentation, the same thing, but this is a negligent misrepresentation. So the idea behind it is that that you're not you're negligent in making the misrepresentation because it's a different class of individuals that's relying on it than the one that you intended to rely on it. So, but if you look at it from a liability standpoint, that this narrower class of third persons than one who intentionally misrepresents something, you're looking at it from a different standpoint. You're liable to those that reasonably would be relying on that, and you've got to be able to show that reasonable reliance in order to be able to show that there was a negligent misrepresentation. Okay, innocent misrepresentation. Okay, does everybody understand what parole evidence means? Because they've got it in the middle of the screen and they don't give you really an explanation, and I'm sure there's an explanation in the book, but is there a reason the slide isn't up? Are you guys not seeing this slide? On the top of the slide it says innocent misrepresentation. Is that not what you all have on your screens? Yes. Okay. All right, good. I just want to make sure we're all on the same page. Literally, we're all on the same page. Okay. So parole evidence has to do with the parole evidence rule basically talks about the four corners of a particular document. That if you have to go outside the four corners of a document in order to figure something out, then it would violate what's called this parole evidence rule. In other words, if you're looking at a page and you're reading it, parole evidence says that you should not have to go beyond the four corners for an explanation, and if you do, you're not entitled to be able to argue what's outside the four corners of the document, because that's what you would have signed if it was in the form of a written misrepresentation. So I see a black screen. Okay, so some of y'all are having some issues, so I'm just going to assume while we're working on this that you guys will get that figured out. So this parole evidence rule is there, and you find parole evidence, especially in contract interpretation more so than anything else. This innocent misrepresentation, as far as product liability goes, if there are misrepresentations on a label. And here's an example. Let's say that there's a machine that is highly dangerous. And when you couldn't hear Susan talking, I could hear. Okay. So I'm not really sure why that happened with regards to Susan and why I couldn't hear, so somebody raise your hand and speak. I just want to make sure that I'm hearing what I should be hearing. Okay, Cindy, go ahead.
Can you hear me okay?
I can hear you just fine. So I'm not sure what happened. I had problems earlier when I was trying to grade some papers, and Canvas was running extremely slow. And while that was happening, I also noticed that it kept cutting me out. And so I was looking at everything else was running fine. I do this class in Firefox, in Mozilla Firefox. And in my other Firefox account, I was online and everything was working fine. And in my Google Chrome, everything was working fine. So I don't think there was my internet service provider. I don't know if any of y'all had these same kinds of problems with regards to Canvas earlier today, but in any event, I think it should be resolved. So, okay. Okay, so in product liability, if you label something and you fail to accurately label it, you have in fact made a misrepresentation. If you have advertised something a particular way and it was for public consumption, this advertisement, and okay, well, like I said, I don't use Chrome for this class because for some reason Firefox is supposed to give a better signal and it's supposed to be better with regards to this class. That's what I was told, and that's so whenever I open up Canvas, I open it up in Firefox. Okay, but when you mislabel something like some kind of a stamping machine, a press, and there should be clear signals. And this is going to be more with the strict tort liability and products liability that comes up next week. But the idea behind it is that it's got to be correctly labeled. If it's an extremely dangerous machine and that has to be warnings and representations telling you that it's an extremely dangerous machine, then you need to know that. And if they fail to do that, then they may have made either a negligent misrepresentation, an intentional misrepresentation, or it may fall under this category of innocent misrepresentation. But there's still strict liability for injury that results from this misinformation. It's just like on anything else that is sold to the general public. If you mislabel it, if you don't describe it accurately so that the average reasonable person reading it understands, in other words, that whatever it is you're trying to communicate is not understood by the average reasonable person, then you may have made this innocent misrepresentation. You may not have been trying to deceive anybody, but at the same time, your misrepresentation was innocent. Okay. All right, so here is the same thing that we just talked about, but in a kind of a chart form. And so now we're going to talk about nuisance. Now, there's several different things that vary when we talk about nuisance. Nuisance, there's both a public nuisance and there's what's called a private nuisance. Both of them involve this substantial interference with your peaceful right to use and enjoyment of your property. I tried a lawsuit against, I represented a homeowners association in the village, and next door to us was a bar. And for the longest time, they had like a sound system in there and they could control the sound and it wasn't that bad. Then all of a sudden, new owners came in and they started putting on live music. Well, the problem with what was going on is that this live music was extremely loud. And in fact, it exceeded the decibel level for sound emanating from a bar, especially an outdoor outdoor area of a bar. And the homeowners complained, and they ended up in an embattled lawsuit for several years against this place. It's called Hans Beer House, and there was lawsuits that went back and forth, and ultimately the insurance carrier came in and the case got settled. But the idea behind it was that it was, Cindy Garcia, you have your hand up? No?
No, sorry, that was by accident.
Okay, not a problem. Okay. So anyway, but the substantial interference with the peaceful use and enjoyment, that's the first element. That's something, whether it's a private nuisance or a public nuisance, that's something that you've got to establish. If you're looking at the public nuisance side, it affects the common public. In other words, it's something the general public has a right in common, and all of them share that right. And so for that reason, that's why it's deemed as being a public nuisance. Whereas with a private nuisance, it only affects the plaintiff's use and enjoyment of their land. So in this particular instance, these were private condominiums that were owned, so it was a private nuisance. Now, if others in the area complained about it, they could have also had private nuisance causes of action. The problem was that it was a commercial area, so by the time this band came on at 8 or 9 or 10 o'clock at night, you know, all the other businesses, there was a Firestone, there was a bank, there were some other places, they were all closed. But the people that owned condominiums, they were all home. And so they were the ones that were most affected for it, and that's why it was a private nuisance. If it's a public nuisance, it's got to be an injury that's by the public at large. If they're exposed to the injury, if they're injured or exposed to the injury, then it's a public nuisance, and it's the plaintiff in a private nuisance that's the one that suffers the injury. A lot of these people in this condominium, the music got to be so loud that they couldn't sleep. They had, you know, they were trying to figure out different ways that they could deaden the sound, and they tried putting up things that supposedly were going to shield the sound, but glass is glass, and if you've got a window, the sound is going to travel right through that glass. In the public nuisance, the people that are complaining about it don't have to have an interest in the land in and around where this nuisance exists. They simply have to show that they were injured or they're being exposed to injury. And the example of the public nuisance that I remember from law school is what they call a feedlot. Like when you have a cattle house or slaughterhouse, and you know, you're killing these animals, and there's these smells that emanate from these places. And I remember the question was, this slaughterhouse existed before developments came around it, and then as the developments, if the wind changed in one direction or another, it was absolutely horrendous. It was like, let's just imagine if you were smelling sewage all day long. And if it's a public nuisance, you've got to be able to show that the plaintiff, whoever it is that's complaining about it, they must suffer damages that are peculiar to him. In other words, they're specific to that person. They've got to be able to prove their damages. And in the private nuisance, you must have an interest in the land. And this would be the difference between the two that I was telling you about. The condominium association that was next to it, that was claiming there was a nuisance, all had an interest in the land because they owned their condominium units. So that's the difference between private nuisance and public nuisance. And in some instances, it can be both a private and a public nuisance if not only individual landowners who are claim injury as a result of this nuisance, but you have surrounding areas or surrounding businesses that also claim an interest in that or claim damages as a result. It can also be a public nuisance. Okay, so this is just going over what we just showed. And the same thing with regards to this. Let me get this slide. I think I need to reduce the size of this. Yeah, now it fits on my screen. Okay. Private nuisance the same way. So they had an interest in effective land. And here's another thing too. Think about it this way. If this bar was left unchecked, and if they could do what they wanted to do and play this loud music every night, which the sound just crawled right up the side of the building, and everybody on that side of the building complained, Can you imagine if you're trying to sell your unit, what's going to happen? You may actually suffer what's called a diminution in market value of your real estate because of the nuisance that was created by this third party. And if you could show that, then that would be an element of damages that you would be able to recover from a third party. And so anyway, and also, and this is another thing too, because some of the people that were living in the condominiums, the owners owned the condominiums, but they leased them to tenants, and they were losing tenants. And if a tenant canceled his lease because the music is so loud and you can't control them from doing anything and they moved out, then you would be able to show actual damages because your lease was terminated. Now, as soon as you're able to lease it to someone else, that's called a mitigation of damage. You have to release it. You could then, your damages would be cut. But think about it, somebody moving back in, as soon as they moved in and this music was played and so on, you would probably lose them as a tenant. So there could have been two different things happening with a private nuisance. One would be a diminution in market value, and the other would be a loss of revenue if it was a rental property. Okay, so what's the difference between a nuisance and a trespass? When we're talking about a trespass, that's the actual interference with your ability to possess your piece of property. In other words, something has happened where somebody has encroached on, let's say, on your land, and so that area of encroachment is a trespass, which kept you from being able to possess that property. Whereas when we're talking about nuisance, we're talking about what's called, it's referred to as the peaceful use and enjoyment of your property. Everybody in the city has an absolute right, when you buy a piece of property, that you are entitled to the peaceful use and enjoyment of your property. The city codes do enact certain sound restrictions and sound ordinances. However, they don't come into play until 10 o'clock at night. Now, for some people, 10 o'clock at night is early, and some people it's late, I guess, obviously depending on your age. But if it's a Tuesday night and you've got a 6 a.m. Deadline in the morning, 10 o'clock at night, is the time that you're wanting to go to bed. And if this sound reaches a particular decibel level greater than that, which is what was happening with the private nuisance, then you would be able to argue that your peaceful use and enjoyment of the property has been interfered with. And it can't just be a minor interference. It can't just be something that happens and once a month or something. It has to be on a regular, and usually you have to be able to show some kind of pattern of conduct. So those are all elements with regards to nuisance versus trespass. And so now we're giving a little bit more explanation as to what constitutes substantial interference, because the word substantial is a very subjective term. However, they've tried to make it a little more objective, and here you see exactly what my lawsuit was about, the second of the two bullet points. First one is obnoxious odors. That's the one that I was telling you about with the slaughterhouse. And the second one with these blaring sounds, that was these live bands who, instead of cutting off at 10, they would continue to play until 11. Even if you get a permit for a festival, you can only play until 10 o'clock at night. Associated with this group, the Italian Cultural and Community Center. And every year we put on something called the Italian Festival. And we, the last 5 years, I believe it's been, we put the Italian Festival at the University of St. Thomas. However, at 10 o'clock at night, we have to shut our stage down. Now, we can play music that can continue to go on, and it's just, Italian music and so on and so forth. But as far as our live bands, at 10 o'clock, they have to shut off by city ordinance. And that was another violation of the blaring sounds. Susan, what's the difference between common law fraud and fraud by misrepresentation? It depends on the action. It depends on against whom it's being done. It depends on the intent, whether or not there's intent to deceive someone. So a lot of people talk about common law fraud, but a misrepresentation can in fact be common law fraud. So there's a lot of different elements as far as what's taking place when you're talking about different types of fraud. There's fraud in the inducement. There's statutory fraud. There's what we call common law fraud. There's a number of different elements. And so there's common elements, but a lot of it you look at it as far as the intent behind what's going on, and you also look at the damages that are sustained. So a lot of those things will be part of the elements of both common law fraud or fraud in the inducement or statutory fraud. Statutory fraud generally is more involved with real estate or real property with regards to statutory fraud. So intent is the difference. No, I'm saying that there can be a level of intent that would be different from one than versus another one. When we talk about fraud, when we're talking about, in other words, if you didn't make a misrepresentation but you defrauded someone by, let's say, your actions, that could be common law fraud. But if you make an actual misrepresentation upon which someone relies, and which you know they're going to rely, and upon which that reliance is to their detriment, then that's going to be a fraudulent misrepresentation. So, so there's a number of different elements that between each of the different causes of action that can distinguish one cause of action from another. Common law fraud may not require in other words, you could infer something and allow someone to believe it simply by fraud as an omission. Did y'all understand? So if you prove intent not to fraud, it's mute. No, because it can still be negligent misrepresentation. You know, the intent, when we're talking about intentional misrepresentation, that's generally, we're talking about intentional fraud, okay? So that requires intent. However, there are circumstances where by what we call crimes of omission and crimes of, or not crimes, but acts of omission and acts of commission. An act of commission means you're actually doing some kind of an act, and that is the basis for whatever it is you're complaining of. But an act of omission means that you fail to disclose something to someone. Here's an example. Let's say you're buying, somebody's comes to you and they're wanting to buy your car, and you know that the transmission is on its last leg and it's about ready to go, and you put some things in there, you know, or you put transmission fluid, or you change it out so that it doesn't appear that there's anything wrong, but you don't disclose to them that what you know to be a defect with the product or the car that you're selling. And so in a situation like that, that's an act of omission. So you omitted to tell them what was wrong. You've defrauded them no matter which way you look at it. So that's why there are you know, a lot of different, and that also falls under, some of y'all may have tried to do this, and I'm not sure if it was in this class or my civil procedure class, but when you were putting a petition together, you were trying to use what's under the Deceptive Trade Practices Act, which is the Consumer Protection Statutes, as your original petition, because I saw that language in there, that 1750, 1756, 1748, all of that under the Vernon's Texas Code Annotated, VTCA, and some of you were pleading that. So, but there's, and the idea behind intent is going to be, was it a negligent misrepresentation or was it an intentional misrepresentation? Okay, so interference with business relations. This falls under a number of different categories. Normally we're talking about a contractual relation. If you've got an existing contractual relation, and I don't know how many of y'all have been around here for you know how many years, but I guess it was back in maybe it was the 90s. There was a case, Pennzoil versus Texaco. Does anybody remember this particular case? Because it made all the news in the world, because it was the largest. It was a multi-billion, with a B, dollar judgment that Joe Jamail got against Texaco, because Pennzoil was the idea behind it was that there was a deal between Pennzoil and a third party, and Texaco came in and interfered with that deal, and that deal, you know, which was what we're talking about, existing contractual relations, and the damages that were sustained by Pennzoil were in the billions. And because I remember Jamil, he got like a $1 billion attorney's fee in that case. Everybody in the office, you know, all the staff and everybody got $1 million bonuses, and it was a unbelievable, valuable case. But fortunately, you had Texaco, which could pay that. But that case went up on appeal and went up to the Texas Supreme Court and was upheld on appeal. They may have reduced the damages, but it was still $1 billion reward, Pennzoil versus Texaco. And that was a tortious interference with an existing contractual relations. There's also an element to this that's called tortious interference with prospective contractual relations. That means that you don't actually have a business relationship with someone, but you're meeting with them and you're trying to establish this business relationship with this third party, and somebody knows that you're trying to do this. They interfere and cause that third party now to no longer do business with you. That is a tortious interference with prospective contractual relations, which may be the next slide. Let's see if it is. Yes, it is. Okay. And so the difference between the two is one has an existing contract and one has a prospective contract. But even though they're contractual in nature, the point of it showing is that it's still a tort. It's still because it says interference with business relations, but it's actually tortious interference with prospective contractual business relations or tortious interference with existing contractual or actual contractual relations. In this particular instance, like I said, there's no actual contract in place, but the parties are in negotiation for a contract. So you're going to have to be able to prove those negotiations. And they show a couple of damages here that a plaintiff is driven out of business. Whoa, what happened? I just lost my slides. Let me see if I can get that back again. So I don't know what happened. Can you guys still see and hear me okay? Yes? Okay. All of a sudden I lost my screen and everything was gone. So I think we're on slide number, well, I'll find it, innocent. Tortious, where's my tortious? Nuisance. Substantial interference. There we go. Existing and prospective. This is where we were. Okay. All right. So misuse of legal process. Okay. Malicious prosecution. I brought a malicious prosecution case against Astroworld because there was a security guard that had my client arrested, and in order to do that, you've got to be able to show that the criminal. God, I just lost it again. What is going on here? I'm not sure what's going on here. I keep losing my... Sorry. We get back to where we were. Hopefully we can get through this session and then it won't happen when we go to the next chapter. Perspective. Okay. So malicious prosecution. So I was telling you about a malicious prosecution case that I brought against Astroworld because their security guard had my client wrongfully arrested, but you've got to be able to show that when somebody institutes criminal proceedings against someone, you've got to show that the case was decided in their favor, in favor of the person. Let's say in this case, the defendant that was arrested. You'd have to be able to show that. So there's a number of different causes of action that are very, very similar to each other. But malicious prosecution is an extremely difficult cause of action to be able to make. And a lot of courts don't even like to have these cases come in there. But occasionally somebody takes it a little bit too far, and then you're able to bring those kinds of actions. This wrongful institution of civil proceedings, this is what they in fact, what is going on here? All right, I'm going to try to get through this quickly so that we can get outside of this chapter 10, or else we're going to be on this thing all night. This is what I was telling you. I was having difficulty with Canvas earlier, and I'm wondering if this is part of the problem. All right, so here we go. Malicious prosecution. So there's no probable cause. Criminal proceedings are brought against someone, and you've got to be able to show that there was no reasonable basis for having brought the malicious action against someone. Wrongful institution of civil proceedings. I had a case where I had an individual who was constantly suing these people for breaches of credit card, even though he had no agreement with them. And by the fact that they would have to hire lawyers to defend them constantly, he got them to settle with him over and over again. Well, we finally brought criminal charges against this individual, and the criminal charges stuck. All the lawsuits were dismissed. He was called what's called a vexatious litigant, somebody who constantly files lawsuits that have no basis. And so same thing that if you continue to bring an action against someone for which you have no reasonable basis, and the courts can also sanction you for these same things in addition to dismissal of the lawsuit. And the last slide for tonight is this misuse, in this section, misuse of legal process. If you don't have you use individual things to basically harass. This is done for what's called purpose of bad faith or harassment. If you issued subpoenas, if you subpoenaed individuals to appear at the courthouse, what you're doing is you're harassing someone to the point where they basically throw up their hands and then they pay you what you're looking for, and as a result of that, you basically have committed this particular tort. You don't see this very often. And what more often than not you'll see is somebody that files what's called a bad faith claim, and you show the court that it's a bad faith claim. You get the court to dismiss the claim, and then you seek sanctions against them, which can be in the form of damages, and usually the damages that you sustain are in the form of attorney's fees, and you get the court to award those attorney's fees. Okay, so that was our last slide for tonight. So I am going to go right into, because entire screen, no. Into chapter 13, which has fewer slides, and let me see if I can bring it up. Okay, so this is chapter 13. Oh. No, this is not supposed to be chapter 10. chapter 13. Share. Okay, defamation. So we're going to talk about these related torts. Okay, so when we're talking about defamation, we're talking about something that's resulted as a result of either the spoken word or the written word. If it's the written word, it's libel. If it's the spoken word, it's slander. And what you've done is you have said something that is untrue. And I don't know why this is doing this to me tonight. I've never had this problem before. Anyway, thank you. It does. I mean, the technology is great, you know, because the video is great. It's almost like a live. I mean, it is live, but it's much better than it was before, and when it was just straight blackboard. And it's better, but at the same time, we still run into these issues and occasionally. And this is the first time, I think, though, over the course of the last 6 weeks that we really had these kinds of issues. So that's not so bad, 1 out of 6 times. Okay, so libel versus slander. So libel is the written word, and slander is the spoken word. If you publish this every time you say you had bad, you know, and I'm wondering if I see other people are having issues tonight, and I'm wondering if whether or not there's something going on with Canvas through the school that we're having these problems, because I had difficulty grading. I couldn't grade all of the things. I tried for an hour to grade and I got one set done, and that's all I could do because it kept, you know the way the little wheel just keeps turning like it's connecting. Well, it kept doing that to me, and finally I just gave up and I said it's not worth my time. So anyway. Okay. Yeah. Well, I've already sent an email to Eric with a trouble ticket when it happened earlier, so he's aware of it. So actual malice is required in the sense that it's got to be a reckless disregard for the truth, or with actual knowledge that the statement was false. In other words, when you spoke the statement or when you wrote it about someone, if you wrote it and it was actually that you either didn't care whether it was true or not, you were still going to put it out there, or that you knew that it was false at the time, either one of those constitutes actual malice. So this kind of stuff is borderline stuff that we've got going on in today's political climate, where people just decide to make statements about individuals, about people, and they say sources tell us, and there are no sources. Now the problem is that when you're a public figure, we're gonna talk about some of these things. When you're a public figure, these things you're expected that these things are going to happen to you, but however, the New York Times has been sued under libel and causes of action, and they've been sued successfully. So there are, we have to gauge this against the freedom of speech, but at the same time, freedom of speech only goes so far. Like, you can't be in a theater and then stand up and yell fire because it's your right to speak, because if you do that, then you're going to create chaos. People may be injured, damaged, all kinds of things. You don't have that absolute right. So freedom of speech is so that if it's true. Now, if there's actually a fire and you stand up and yell fire, well, then you're doing everyone a favor, but not if it's not the case. You've got to be able to show a particular harm. You've got to be able to show money damages. If you can't show money damages, then you might be able to recover, but it's basically going to be what we call nominal damages. They may have an action that says that these people committed the act, but they couldn't find any damages to award to someone. So there are 4 exceptions. These are what we call libel or slander per se, if they fall into those last 4 categories. If you impugn someone's character saying that, like for instance, the third bullet point, that their business is that it's a terrible business, that what they're doing is that they perform a terrible service, and it's untrue. That's going to be libel or slander per se, whether you wrote it or you spoke it. Criminal behavior. If you impugn, and I remember in law school they used to tell us that basically it was like the chastity of a woman. You know, that if someone was, you're saying that they were an unchaste, they were a slut. And if you made that kind of comment and you published it, and a publication simply means you told a person. So if you put it in writing, each time it was printed and it went to someone, that's a publication, and each one of those publications gives rise to damages. If it's spoken, each time you speak to a person and tell them this slanderous story, that's a publication, and each time that gives rise to damages. Somebody that has what they used to call it a loathsome disease, but if you say something about someone that they have HIV, or that they had herpes, or they had just some other kind of loathsome or communicable disease, that is libel or slander per se, if in fact it's not true. And then just remember, truth is always an absolute defense to a libel or slander action. If whatever you said was actually the truth, then that presents a particular type of a defense. And sexual misconduct, and that kind of ties into what I was talking about before about the chastity of a woman. And more often than not, if you were to have made representations that somebody was, I don't know, that they had low moral character, all of those kinds of things, that would be per se. Okay, so we just already talked about this, that one is in written form and one is oral form. And then this is just the chart version of what we just talked about, what constitutes libel and what constitutes slander. Obviously, one is spoken word, one is the written word, and you've got to be able to prove, and look at this part right here under slander, the second bullet point. You must prove special harm unless it's slander per se. If it's slander per se, and those are the four categories from before, right? Chastity of a woman, loathsome disease, disparaging a business, all those four categories, if it was one of those, that's per se, and you don't have to prove the special harm. You just have to prove that it was false, and that's how that works. So what is a defamatory statement? So when we're talking about something that's defamatory, we're talking about something that is intended to harm an individual. And what can it be? What if you're simply painting somebody in a light that's unfavorable to them? Well, if they sustained harm or damage as a result of that, and it was not the truth, then it will meet one of the elements of defamation. The idea behind it is that someone, and that's where they talk about publication. That's on the 1, 2, 3, 4, 5th bullet point. Statement is seen or heard by someone other than the plaintiff. The idea behind that is that each time you publish it, it goes into a newspaper, it goes online, and somebody opens it up. Every one of those constitutes a publication, and for each publication, that constitutes harm. And then again, there needs to be actual malice. If the plaintiff is a public official or a public figure, then you've got to be able to show that, not such that there was not actual malice, but you must show that in fact there was actual malice, that you did it with the intent to harm that individual, as opposed to having made a comment which was reckless. And so the idea behind, that's the public figure issue, is that you have to intend to harm them in order for a public official to be able to recover damages. Harm to reputation, so that's one of the things that you would prove with regards to proving your damages. And again, having to be published, that simply means that if it's the slanderous word, it's spoken to someone other than the plaintiff, every person it's spoken to, that constitutes a publication. and if in fact it's or it can be done negligently if you continue to go on with conscious disregard for the truth or the falsity of the statement. Was Trump slanderous about the bug? Well, he wasn't. Let's look at that statement. So Donald Trump said something about Obama had Trump Tower bugged or wired during the election. Now, you look at it and you say, well, it's not a loathsome disease, and it's not it's not disparaging his business, but it would fall under criminal behavior because that's the same thing that brought down President Nixon. He bugged the and broke into the Watergate apartments, and as a result of that, he ended up resigning from office. It was criminal behavior, and they did not criminally prosecute him because he resigned from office. So, but the situation with Obama, that could constitute criminal conduct if they could show that he did it. But the thing about it is that the individuals who said that denied it, it's funny because they're making these distinctions, and I don't know how true these things are, but they're saying that the White House denies having bugged Trump Tower. They never said that the Obama administration didn't bug Trump Tower. They're saying that the White House didn't do it. Well, by denying it and having that what we call plausible deniability, that there may not be a criminal act that Obama would have, so that may then in fact not be actionable. So that would be one way to look at it. Defamatory statements. How do you defame someone? What is it that you're talking about? So we already talked about defamation per se, right? We talked about those categories about impugning somebody's reputation, that they have a loathsome disease, that they're engaged in criminal conduct. All of those things are per se. But now let's take it away from there. Now we're just talking about statements that are made that are untrue about someone. Is someone's reputation harmed? Or is there a tendency that it would be harmed as a result of the statements that were made? And the interpretation by the hearer, the person that hears this slanderous or libelous statement, which both are defamation, is that a reasonable interpretation of what the speaker said or the writer said? And then if at least one interpretation, one reasonable interpretation could be that it was in fact a defamatory statement, then it is. And the statement is false, which means that you either knew that it was false or you acted with such disregard that you didn't care whether it was true or false. And then finally is the publication. And publication again means that every time it's published, every time it's put out there, each time that constitutes an act for which you can recover damages. So then you have to be able to show some kind of pecuniary loss. The case is always the strongest if you can show some kind of pecuniary loss. Excuse me one second while I get a drink. Oh. Okay. So if you can show that monetary loss, then that bolsters your case, and it makes your case that much easier to prove. However, non-pecuniary losses in the form of, let's say, a loss of friendship. Somebody makes a statement, and as a result of that, your friendship is destroyed, your relationship is destroyed. That can actually be actionable defamation. Let's say that you fall into a deep state of depression, clinical depression, depression that was diagnosed. So that is actual physical harm. That could also be. And the fact of humiliation, it's got to go beyond humiliation, just that, like, I don't know, if somebody was in class and they said something stupid and somebody made a comment, that's your kind of your plain vanilla humiliation. This has got to go beyond that. This has got to be the kind of humiliation that would actually shock the conscience of a juror, and in order to get them to be able to come back. Is this where revenge, porn? Okay, so I don't know about revenge porn, so I'm not sure. I don't know what that is. Revenge porn. I don't know what is that. You film yourself having sex with somebody as revenge, or you film something with somebody and then you publish it. I'm not sure which direction that goes. But in any event, exes. Oh, well, um, if you have the right to be able to film someone at the time that they gave up the right to be able to complain about it, and they also gave up the right about most everything with regards to that. That's why, I have a girl sends you nudes or you film yourself, then she angry puts it out on the web. Yeah. Well, here's the thing. I have a 14-year-old daughter, and I'm always telling her. I said, look, you might get at your age when you're in junior high school or middle school and high school, you hear about girls sending these naked pictures of themselves to guys, and they think that it's just sending it to them, and then that guy sends it to like 100 other people. Well, you lost your rights. As soon as you gave up the right, you lost your right to control what's going to happen with that, and that can be anything. Once it's out there, then you lost the privacy rights to it. So that's why you've got to be very, very careful about being in a situation where you allow someone to take those kind of photographs of you, because once you've given them the permission, you lose the right to be able to claim that your privacy rights were just like going on in the Marine Corps right now. Absolutely, there was just in the paper today. Yeah, it was, at least I read about it today. Right. Well, I had this stuff happen with my daughter, and there was an innocent picture that she had sent of herself, and it was just a picture, and she was fully clothed, and it was kind of a cute picture. And this kid at school, he made a comment. He took her picture, and then he put a caption underneath it, and he says, "This is the face of non-consensual sex looks like before penetration." Okay, this is a 14-year-old kid, and this was my daughter. And I printed out every one that little son of a bitch did, and I took him to the school, and he was expelled for it, because in essence he was saying this is what someone looks like just before they're raped, and that's what he did. And so I'm not sure if I did my daughter a favor or not, but everybody in that school, they know not to mess with my daughter, because they know her father will go there and kick their butt. So figuratively kick their butt, not literally kick it, but and so this kid was suspended from school, and so you at some point in time you got to take a stand, and there were other girls that were involved, and none of the other parents were taking a stand. So anyway, I fixed his wagon, and the principal suspended him, and it'll be on his permanent record as well. So sometimes you just have to take things in your own hand. I don't like anyone. I'm very, very protective of my daughter, and I didn't like seeing something like that. And so and I recommend, if that happens with any of your children, it's not funny, and it's too easy for these kids today with regards to this electronic age that we live, and they do Snapchats and they do all these kinds of things. You got to watch what's going on there, and you got to be very, very cognizant of it. And if somebody violates it, you got to go in and tell them. Exactly. So okay, so here's a summary with the defamation. Public figures and officials, now for you, like you guys, if somebody said something, they impugned your chastity, or they said you had a loathsome disease, or they said that you were engaged in some kind of criminal conduct, or they impugned your business or your profession that you were in, you as an individual would not have to prove actual malice. But if you're a public figure, or you're a public official, or you're in the public limelight where the things are being written about you all the time, then you have to be able to show actual malice, meaning that they had this intent to harm you, as opposed to just putting it out there without determining whether it could or couldn't be true. But if you're a private figure, you don't have to prove actual malice, but you have to be able to establish that it was false, and that if it's a matter of if it's a public matter, then you've got to be able to show then negligence. And if it's a challenge statement involves a private matter, private plaintiffs need to prove actual malice to recover presumed or punitive damages. So the defamation is not an easy cause of action to make. But, you know, in the right situation, somebody publishes something, you know, it injures you, it damages you, you're a private figure, and you know that they did it maliciously. That can be worth, you know, it can be a seven-figure case if you can be able to show the right elements of damage. So, privileges. Okay, so this is kind of interesting because I got sued before because of comments that I made in a lawsuit on behalf of my client. And they turned around and they filed a counterclaim against my client, and then they sued me in the counterclaim, which I have an absolute privilege. As a lawyer, as a party to the lawsuit, I have an absolute privilege that I can say in the lawsuit whatever I want to say. And the same thing with judges and parties and so on. If it's during a judicial proceeding, you have an absolute privilege to make statements. And so, you know, when I had to call my malpractice carrier, and they came down to the judge's chambers, and then the judge told this girl who, I guess she'd only been practicing for a few years, didn't understand that you can't sue the lawyer. You can file a counterclaim against the client, but you can't counterclaim against the lawyer. So she finally dismissed all the claims, and then and ultimately she dismissed her entire claim against my client. So if you look at those different situations, and husband and wife, there's an absolute privilege. Attorney-client, absolute privilege. Pastor penitent, we talked about these before, I think. There's absolute privileges that are all in existence. And then there's the qualified privileges. That means that you do have a privilege under certain circumstances. And if you're simply reporting a public proceeding, like let's say something that happened down at the courthouse, and you're simply reporting things that were said or done in that proceeding, then there is a qualified privilege you as a reporter would have, because you're simply reporting what was done in something that was public. And then there's someone with capacity to act, statement made to someone with capacity to act in the public interest. That would be a public official, and statements made to protect one's own interests. So long as it's not a business thing where you're trying to gain a competitive advantage against another type of business, there is a qualified privilege that you can make statements, so long as there's not this competitive advantage that you're trying to gain. You know, people make statements all the time, and it's funny because you see this especially with these cell phone companies. And they talk about it, and then, you know, there's Verizon covering the country, and then they talk about someone else that's coverage is as good, if not better than theirs, and then they talk about overpricing. So they're basically slamming these other businesses, but that is deemed as being fair trade. You can do that, and when you publicize something and somebody comes back and they make a comment about what you've done publicly, that's deemed all as far as being fair game. Okay, so this is the newest part of defamation on the internet. The idea behind this is that, and you know, there are companies that if you find defamatory statements about you, you can contact them. And I can't remember the name of it, but they'll go out and they'll search the internet for anything that involves you, and everything that they find, they'll come back and they'll clean it up, so to speak. And what they basically do is they go to the people who have published these things, and they tell them. I represented a doctor who treated cancer patients in Mexico. And he was very successful with a lot of the treatments, and then a lot of people thought that it was just snake oil, that he was, you know, taking money from these people and not really helping them. And some people wrote some bad reports. So long as it's simply your opinion about whether somebody was effective or not effective, that's okay. But when you change that to being statements of fact about someone and you're publishing it, now you make it more actionable that somebody's being damaged, and you can prove, what from the time that these statements came out, what you were doing before then, and then since the statements came out, what you're doing, and you can show that loss of that pecuniary interest, it can be actionable. The idea behind it is that most of these people do these things anonymously. So, and you can post it, and nobody knows that it's you that's doing it. However, there is a trail that leads from everyone. As soon as you type something in on your computer, there is a trail that is left, and you can trace that. The problem is the expense, the cost involved in doing that kind of tracing sometimes outweighs the value in doing it. So anyway, so there is legislation making it more difficult for those to recover against internet service providers. Not the people that are making the defamatory statements, but the internet service providers who are putting that information out there. So there needed to be some form of protection, and they got it through this Communications Decency Act. Now, if they become aware, let me see if they give you the details of it. No. I remember the statute, and if they become aware that these slanderous or these defamatory statements are being made, and after having been made aware of it, they don't do anything, I think that's when they lose that. It's kind of a qualified privilege, and they lose it at that time. Invasion of privacy. Okay, so when we're talking about invasion of privacy, more often than not, the cause of action is going to be the third one, which is the public disclosure of private facts. That's the guy that kind of is in your backyard and you don't know it. You just happen to have your blinds open, and you're walking from the shower to the bedroom, and they snap pictures and they publish those kinds. You have an absolute right to privacy within the confines of your home. There's also other aspects to that, because that also includes and involves the second bullet point, which is an unreasonable intrusion. You have the right to believe that your privacy is sacred as long as you're in your home. And if somebody intrudes on that privacy and then they disclose these private facts out there to the rest of the world, then that can be a cause of action for an invasion of privacy. If they appropriate or misappropriate information that's of a private nature and they publish that information, that also can be actionable. And if they do something that portrays you in a false light, let's say that they, oh yeah, that's right, Erin Andrews. I mean, that was she got a lot of money off of that deal. And you know what was so weird about the Erin Andrews? I mean, I saw the video and before it was taken off of the web. And here's this girl, and she's a very, very attractive woman, and she's got a great body. And she's standing there in front of a mirror, and she's just standing there completely naked, and it's almost as if she was posing. And it just went on and went on and went on, and the guy did this reverse camera that he put up to the peephole and was able to film what was going on. And one of the reasons why she was able to recover is because the hotel allowed this guy to do this. I don't know who he paid or how it was, but both the hotel and the individual were found liable, and they paid out literally millions of dollars to Erin Andrews. And she got a ton of publicity. Everybody knew who she was, and I can guarantee you that, for all the tears that she was crying in the courtroom, that was the best publicity that woman ever had. Yeah. Now, yes, she was portrayed in a false light, and if that came, yeah, they paid a lot of money with regards to that. But anyway, those are the kinds of things that constitute the invasion of privacy. Okay, so the appropriation, or it's misappropriation, where you take something that you don't have the right to use and you do it in a means that you gain value as a result. Okay, so these cases, the appropriation cases or misappropriation cases, are the ones where you have, like the National Enquirer, they try to get these photographs of someone, in compromising positions or something. They've been sued a number of times, but they make so much money off of idiots buying these rag sheets that they can afford to pay out these damages just because they make so much money because everybody goes out and buys these things. I don't buy them, but I hope y'all don't buy this stuff. But it's I just think it's a bunch of garbage. I said we already talked about the reasonable, unreasonable intrusion, the public disclosure, and the false light. All of those. Good. I'm glad y'all don't subscribe to that stuff. So that's what constitutes this invasion of privacy, and that ties into the defamation and this libel and the slander and so on. So this was a short slide for this particular chapter tonight. This is the last slide that we're going to have, so I'm going to get you guys out here a little bit earlier. So let's talk about this injurious falsehood. So we're talking about, and a falsehood obviously is a lie. So we're talking about in the business context, if you make a false statement about somebody's goods or services that they're selling, and it's done for the specific purpose of getting people not to do business with them, then that becomes actionable because you can be able to show. The problem is, and think about it, if you started talking about a particular product and you said that this product was no good, and you said that this product, the services were terrible, and the problem is that it becomes difficult to prove that the damages that you're sustaining today were as a direct result of that injurious falsehood, that trade libelous statement made, or is it just the market cycle, and this is just time because we don't, when you're making money, it doesn't mean you're making money every quarter. There's some big quarters that you lose money, and as a result of that, it becomes a little bit more difficult to be able to prove that. Slander of title has to do with real property. It has to do with basically you're saying that somebody is not the true owner of something, or you're disparaging the title of a piece of property that's owned by someone. So those are the two with regards to injurious falsehood. Trade libel, which obviously is that you're making a false statement about the goods or services that a particular business sells or provides, but again, you've got to be able to show that there was an element of damage. You've got to be able to prove those damages were directly related to this statement having been made. Okay, so that is our two chapters for tonight, and so this is what's going to happen. So next week I am going to be out, and I will record the chapters for next week. So next Monday night, tune in regular time, and you can watch. And obviously there won't be a live session. It'll be me just like I'm doing now, but I'll give the explanations, and I'll tell stories just like I do anyway, and we'll talk about that. And that has to do with I believe strict tort liability and strict tort liability. I think those are the chapters that we're going to be covering for that one. But I will record those, and then Eric will post those. And please explain discussion 8 chapter. Don't remember a breakout room. We don't have a breakout room. That was put in there before me, and so there is no chapter 8 discussion. What is the cut and paste? I'm not sure I understand. I'm not sure I understand what
the one of the assignments chapter 8 that you broke us into groups and we had to cut and paste.
Okay, and so what is your question with regards to that?
We never broke out in groups.
Oh, I understand what you're saying. Okay, all right. Well, and I'll just be real honest with you. I don't do breakout groups, and so I don't know why that was put in there for that, because you're going to find the same thing at the very, very last session. It also talks about breakout groups, and so when I come into is that a graded exercise?
Yes, it is.
Okay. All right. Then don't worry about it. I will take care of that one. I'll either eliminate it or everybody will just be given full credit for it. But we never did go into a breakout room, so you wouldn't have that, and it's not your fault, and it's not going to be your problem. Okay, anybody else have any questions? All right, so you guys have a good week, and I'll see you in a week, and I will be back, but I will record everything, so just you'll see it posted, and we'll go from there. All right, you guys have a good evening, and I will see you in 2 weeks.